because you read the memoir and you called me up and said, there's certainly different things that you do not agree with Ben Bernanke on. And there's one particular passage Bernanke writes where he says Hank Greenberg, quote, was evidently unwilling or unable to curtail AIG's financial products' risky activities. Most of the credit default swaps that brought AIG financial products to grief were originated between 2003 and 2005 when, as he implies, Hank Greenberg was running the company. How did you feel when you read that?
Well, it's totally wrong. In fact, in the 9 months after I left the company, AIG did more than we did in the whole 7 years before that.
More credit default swaps.
Yeah, it's totally wrong. And we have facts to back that up, of course. I sent them a copy of the book that I wrote with Larry Cunningham.
Right, the AIG story.
Yeah, which outlines it all. It's all, and there's a bibliography that supports everything in the book. Mm-hmm. I didn't find that in his book.
Right, he didn't quote your book.
He didn't quote the book or didn't have the facts.
So why would he say this then?
You have to ask him. I have no idea.
So, Hank, did you get any response? So you wrote Bernanke himself. Yeah. You wrote him a letter. You gave him all this information. Did you get any response?
Not one.
Not one? Nothing. Okay. Did you expect any?
No.
Okay. David, and I see you smiling there. I mean, you also obviously differ with these, with these details that Bernanke wrote. What do you make of that, of those remarks?
Well, remember, these really aren't details, particularly when you're talking about whether these transactions, what Chairman Bernanke calls insurance transactions, were or were not risky. Remember, the judge, after a several-week trial, held that AIG had stopped writing these swaps 2 years before Bernanke himself recognized there was a problem. In 2007, almost 2 years after AIG had totally stopped engaging in what Chairman Bernanke calls insurance of these swaps, Bernanke was still giving speeches saying there was no problem with these mortgages. And one of the things the judge says very explicitly, and it's accurate and reflects the evidence, is that AIG was not in any way the cause of the financial crisis. It was a victim of the financial crisis. It wrote this insurance based on misrepresentations, and it stopped at the end of 2005. It's exactly true, as Hank says, that AIG wrote more in the 9 months in 2005 after Hank left than they had the entire time he was there. But AIG stopped at the end of 2005, years before the regulators, including Chairman Bernanke, recognized there was any problem. So if there was a problem here in failing to recognize the risk that was being taken, it was on the part of the regulators more than it was on the part of AIG.
Right, because the implication there is that Hank Greenberg, you already knew that there were problems that could arise from these credit default swaps.
Absolutely.
Do you think, Hank, you and I have talked about this many times, do you think that Bernanke, Geithner, do they target you? I mean, do you feel like you're being targeted by them with some of their remarks? The fact that they're not listening to you, what you say is evidence?
Well, I don't think they're listening because they've made their mind up what they wanted to say and do. The fact is that they overreached, way overreached on behalf of the government. That's what the lawsuit is all about.
Yeah, it's more, and it's more than that they just overreached. They did overreach, but they made AIG, and they admitted this at the trial, a political scapegoat. They were trying to demonize AIG for their own political purposes, and they had to admit that at trial. And so a lot of what you're seeing now is simply an attempt to support what they felt they had to do for political reasons during the crisis.
Well, and Bernanke titled that chapter, AIG, It Makes Me Angry.
Yeah, that's what made me angry.
I think there were a lot of people that were made angry.
Yes. Okay. Bernanke also wrote about the lawsuit that, Hank, you filed against the U.S. government on the bailout, which I know Hank has described as a takeover. And he called the lawsuit, basically, you both have a lot of chutzpah, he said, right? That was his word for going ahead with it. And he also said, David, this is to you, despite that you're doing this lawsuit, you're filing it, despite the fact that AIG's own irresponsible actions were the source of its predicament, and despite the fact that the AIG board voluntarily accepted the Fed's terms, recognizing that bankruptcy would leave the shareholders with nothing.
There are three things wrong with that, okay? First, as we've just talked about, the judge found that the financial crisis that AIG was suffering from was not AIG's fault, but indeed had been brought about by the government, by Chairman Bernanke and Tim Geithner and the Treasury Department. Second, at the time that AIG engaged in these transactions, it had no more reason to believe that they were risky than anybody else did. Mm-hmm. They were, in fact, misled by the people marketing these securities. Third, and this is critically important, there was no dispute as to whether the Fed could give AIG a loan. There was no dispute that
so you
the
don't
Fed
argue with
could
that.
Charge an interest rate.
The loan was appropriate.
The loan was appropriate. No one's ever challenged that. What's been challenged is the fact that the Fed, without any congressional authorization, contrary to what Congress had written, confiscated 80% of the shareholders' equity. They had no power to do that. The court has ruled that.
Right.
The court has ruled this was an illegal act. And when the executive branch in our democratic society takes power for itself, not that's been given to by Congress, there is simply no limit to that power. That's a very, very dangerous thing to do. And I think that the thing that's really important here is that people understand that what this case is about is not about really AIG or even about bailouts. It's about whether government agencies can take power that democratically enacted legislation has not given them and simply do whatever they want, take people's property without any authorization.
Right. Again, that goes to the overreach of the government. But Hank, Bernanke would say, to justify those actions, he'd say that, to give that much of a loan to AIG, the American taxpayer needs the insurance, the guarantee that they'll get paid back.
I think he said also that the AIG had plenty of collateral, enough collateral to cover the loan. So there was no reason whatsoever to violate the law and take 80% of the equity. It was against everything that was, all of it was clear. Mm-hmm. You can't take equity. You can lend money. The Fed had the authority to lend money.
And you said it would have been paid back.
But never in its 75 years did they ever take equity. In any company.
Even if he thought it was a good idea, it's not up to him. It's up to Congress to decide what power the executive branch has. I think he was wrong. I think it was a very bad idea. But even if he were right that it was a good idea, it's not up to him. It's up to Congress and their democratically elected representatives.
So both of you are appealing the judge's decision, Judge Tom Wheeler and his decision.
Yeah, and remember, the government made $23 billion on this transaction.
Right, they did, but Bernanke would look at that and say, "Hey, the Fed made the right decision then by bailing out AIG." Right? They would say,
well, "No, I said just the opposite. If there was that much equity in AIG, the loan was, very secure. Mm-hmm. Why they take equity?
They could have gotten paid back without the equity.
Absolutely."
But I want to get to the lawsuit, though, because it's on appeal right now.
Yeah.
And David, it's going to be heard, I believe, by a panel now.
Yes.
And I believe that given that, there is a possibility, is there not, that the panel could, A, they could rule for damages, but B, they could rule for no damages, but also reverse Judge Wheeler's decision. So do you want to risk that?
Well, anytime you go up on appeal, the appellate judges could disagree. But we feel the law is very, very clear. As Judge Wheeler ruled, the statute is very clear. The legislative history is very clear. The 75 years of interpretation is very clear. It all goes one way. Everybody recognized Even the Fed internally recognized they did not have the power to confiscate equity. That's what this case is about. So I think we feel very comfortable with the appeal. We think the court will look at this fairly and carefully. And we think that not only will they affirm what Judge Wheeler found in terms of the illegality of the confiscation of equity, but we hope they will award some damages too.
You know, Hank, I think you and I talked about this also the last time. I mean, why isn't that decision by Judge Wheeler, why isn't that enough, though? I mean, it was a moral victory. You didn't get damages, but it was a moral victory.
Well, you know, I feel we have an obligation to all the shareholders who lost their life savings in many cases. This lawsuit is not for me. It's for all the shareholders.
Right. We're talking company. Tens of thousands?
Yeah, absolutely.
Okay.
Absolutely.
What do you make of AIG now? I mean,
what do you mean? What do I make of AIG?
Well, let's bring up the stock chart, right? So if you look at AIG now, you know, the stock was as low as, I think, Hank, like $5.60, at the lowest point. This is a 10-year chart. I mean, it's barely gone back up to the heyday when you were there as the CEO. But it is now trading at about $61. So again, Bernanke and Paulson and Geithner and others might look at that and say, you know, this is a job well done.
There was a reverse split. And if you adjust for the reverse split, it hasn't moved very much.
Okay. Okay.
It speaks for itself.
David, why did you take this case on? I mean, I know you and Hank go back a long way, but why did you take this case on?
Well, it was partly because of Hank, but it was partly and importantly, because I think this is a very, very important case to the way our government operates. We give our government tremendous power and discretion. If the executive branch can use that discretion to leverage still more power, there is, as Justice Jackson said in the steel seizure cases more than half a century ago, either no beginning or no end to that power. And that's very troubling for citizens, because what it means is that the government can one way or another confiscate their property without any congressional authorization. Our government is a government of limited powers. The executive branch only has the powers that the Constitution and Congress give it. If you allow the executive branch to begin doing things because they think it's a good idea, even though they've not been authorized to do that, our protections of individual property, our protections for individual liberty go away. And so I think that this is a critically important case to the way our government operates and the kind of rights and the preservation of rights that our citizens need to have.
Okay.